quoted.
I don't
Well,
know.
you're
Because
the
I'm
moderator.
officially
You're the
with-
moderator. You're
Yeah,
okay.
but I won't resist.
No,
I
you're
have
not. You're not
views,
moderating
you know,
here.
and I'm known
Well,
to
I
be
think you're.
sharing my views.
Well,
You're
no,
now a
but your
panelist.
views,
That's what you're doing.
to the extent your views align with the policies you've tried to implement but not been able to, that's fine.
Yeah. Well, my goal is that
You're in the initiative to go to the court, try to bring them in, and yeah, so that's not a problem. It's when you say the Supreme Court are really stupid.
Yeah, no, I don't
Can't
think
do
I
that.
can do that.
Or the law profession
This
is
is
full
when
of
you
that's
kick
crap.
me under the table if
It's
I
full
my
of
God.
You
crap.
can make fun of your younger
No,
guy.
exactly.
Nobody is a younger guy.
No.
I noticed that
King himself is here.
your name is bigger than Rick's.
No, but Rick has his own cards with his name
okay.
first. Those are my
That makes
cards where
perfect
people
sense.
can still
Oh, they
reach
switch
out.
around, that's very
That's
cute.
my
Yeah.
husband, actually. We're both in this area.
Oh, okay.
Yeah, we just
So you're a
created
civil
our-
servant though, right? Are you done, are
I
you
took
finished?
Involved
I
as a
took
student, so I did see him, but I never really got to know him. So, but I understand he was quite a fella.
So you're out, so you're good.
Yeah.
But I'm still
You still, no, you still be
officially-
careful.
No, you'll be careful. That's why I just, I'm not
Okay,
going
so
back.
can I keep on?
Yes, of course, that's yours.
To Newark is.
We're the best anti-financial crime, couple in the
Yeah.
whole planet, right?
Yeah.
Couple, but she's not in this business.
She is not in this business,
It was.
although she knows everybody.
The business.
Very.
Show on the road? Whip him in.
Spell usually brings him in, so.
Oh, right.
Nobody's bringing the, okay.
Ring in the bell.
Thank you all for persevering through the day. It's a long day, but it's been a great day, and we have one more final great panel. The this is going to be financial integrity and compliance, and we have three people who are very knowledgeable on the subject and have also a lot to say about it. So we're very excited to hear from you all. I'll give some brief introductions. Sadly, Carmina Hughes, who is from TD Bank, one of their senior leaders, was not able to make it because of the snowstorm that hit around Lake Ontario last evening. Ambassador Wolf got here about 3 o'clock in the morning. But first, we're very happy to have José Nadeau, who has spent much time with the Government of Canada, was most recently Senior Chief of the Financial Crime International, where she led the Canadian delegation to the Financial Action Task Force and to its regional bodies in the Caribbean, South America, and the Asia-Pacific region. In this capacity, she coordinated up to 12 departments and agencies. In 2012, she led the review of the international standards for anti-money laundering and countering financing of terrorism and proliferation. She also led the ongoing assessment of the FATF countries and high-risk countries' compliance with their standards, and led the ongoing policy development in those areas after the assessment. She also worked in support of Canada at the G7, 8, the G20, United Nations, and the Organization of American States in respect to financial crimes and financial integrity. So somebody with a lot of experience in this field, and now that she is recently moved on from the Government of Canada, is able to share her views without filter, or so I'm told. Many of you know Diane Francis. She is one of the members of our executive committee, a very strong supporter of Cooley, so we thank her for all of her efforts. She's an award-winning columnist, author, investigative journalist, as well as television commentator on all things Canadian and American, and really across the world. But one of her particular areas of interest is financial compliance, integrity, money laundering, and it's something that she's written extensively about, so we're very excited to hear what she has to say on that topic. And finally, we have one of our own Case Western professors, Richard Gordon, who is the director of our Financial Integrity Institute. He's been a professor here for quite a while, and before that had a long and distinguished career in public service. He's a graduate of Harvard Law School. and practiced international tax law in Washington, D.C. in private practice. He joined the staff at the International Monetary Fund, where he was senior counsel and senior financial sector expert. And in particular, he worked on sovereign debt restructuring and financial integrity matters there. After 2001, September 11th, he served on the IMF Task Force on Terrorism Finance and co-led the IMF and World Bank's involvement in anti-money laundering and terrorism financing. So we have three people with a breadth and depth of experience on this topic. And since I'm not the one with the expertise, I'll turn it over to them right now. Thank you, guys.
Thank you very much, Ted. Well, first, I want to say that I feel very privileged for being here today among all of you and with my colleagues here as panelists. But I have a little secret to tell you, a little disclaimer. I'm not a lawyer, okay? So I've been invited to this Canada-US Law Institute thing, but I'm an economist, okay? Just so you know. But I did marry a lawyer, so that counts a little bit. Okay, we'll see. Guilty. Yeah, we'll come back to that. The other thing I want to say is, like Mr. Weeks said so nicely this morning, that I'm not speaking on behalf of the government of Canada. You know, I do say we sometimes and say we as Canada, but also I'm going to leave without pay from the Department of Finance. So I can say a little bit of what I think among, friends, but I'm still a civil servant with the federal government. So I'll have to be a little bit careful, but I'm known to usually say what I think. So what you see is what you get. I want to say that I really, really enjoyed the day so far. So hopefully we'll continue to enjoy the rest of the day together. I feel I learned a lot, and hopefully you can learn a little bit too about financial integrity in this wonderful world that is quite big. So as a moderator, but I'll be a bit of a panelist in a way, especially now that Carmina could not make it. There was also thunderstorms in Cleveland that delayed some of the planes. Anyway, she's been having real problems coming here. But what I'm going to do is go quickly over 5 slides that I have, and hopefully that's going to give all of us the same facts and a bit of background on this topic internationally, but also from a Canada-US bilateral relation. And then I'll let the 2 panelists say a few words as well, and then we have identified a couple of issues for discussion, and we'll take your questions after that. So financial integrity. Maybe you think, oh, why bother? This is boring. This is a bit technical. It's all about money. Well, it is all about money, actually, and it is simply and very importantly, how do we stop or really prevent the bad money into our legitimate, hardworking economy. So it's all about following the money. The key issue, stepping back 30,000 kilometers, whatever system you want to use, the key issue is really, are we effectively tackling money, related to terrorist financing, money laundering, tax evasion, also fraud, corruption, and you name it. So those crimes have huge costs on our societies, and they can very negatively affect a country's reputation. We've seen it with the Panama Papers and more recently, but even before that. The problem with those financial crimes are really global in nature, and the solutions are also global in nature. But sometimes, we all have national sovereignty. Is how can we maintain that and still be a good corporate citizen in the world of fighting financial crime? It's complex. The expectations are high. The challenges are quite broad, but they are quite important. So I'm going to start in giving you some of those little facts and background. So, since the financial crisis of 2008, financial integrity has been more and more on the international agenda. And in the last 7 years, systematically, the G20, mostly finance ministers and central banks, when they meet and issue their communique, they've been calling on this FATF on issues related to financial market integrity, transparency, terrorist financing, and so on. So, what is this FATF? It's the Financial Times actually in one of its article said a couple of years ago the Financial Action Task Force is probably one of the least known international body, but probably one of the most influential on national policies. So I'll tell you a little bit more about the FATF now. It's the standard setter for fighting money laundering and financial terrorist financing. So they officially say anti-money laundering, countering the financing of terrorism. It's a policy task force. It's not operational in nature. There's no cases being discussed per se. It was created at the end of the 80s under the leadership of the G7 by the French. It was at the French G7 summit. This is just the same year, I think, or the year after the UN convention, the Palermo, I always forget, Richard.
Palermo?
The Palermo was the first one, or
The Vienna.
the Vienna Convention that requested countries to criminalize money laundering. So you think that's not that long ago, and at the end of the 80s, money laundering was not even a criminal offense in many of the countries, including Canada. I think it was in the U.S. already. So originally, it was really the leaders of the G7 tasked their finance ministers to do something about the financial integrity of the financial sectors, because they were worried about the huge amount of money from drug trafficking infiltrating our legitimate financial system. After 9/11, the FATF was given the mandate to deal also with terrorist financing, and in the last revision of the standards in 2012, the FATF was also included a couple of standards related to proliferation financing, weapons of mass destruction. So the FATF standards are very comprehensive, and they give you kind of a nice toolbox of how to follow the money. As I said, it's very helpful also to fight corruption, tax evasion, organized crime groups, and terrorism. Currently, there are 37 members at the FATF, and but globally, through regional bodies, over 190 or 80 something countries are recognizing the FATF standards and are also committed to implement them. The FATF is housed, just a little history, is housed at the OECD premises in Paris, but it's totally separate body with members. The BRICS are all members of the FATF officially. And you have all the European countries, of course, the NAFTA countries. And so just sometimes the Europeans are a bit Eurocentric, and they discuss issues that are related to the European Union. So sometimes us and the Mexicans and the Americans like to refer to, and let's discuss an issue that is related to the North American Union. So we like to show a bit of counterbalance there with the Eurocentric approach sometimes to those global issues. So the FATF, as I said, is a policy body, but also does country reviews of the enforcement, the implementation of those international standards. There are formal assessment, peer reviews, and all the reports of the FATF are public, and they are found on its website. It's easy to find on the website. Next slide. So to bring you back to a little bit more into the FATF language, the standards since 1989 have been revised at least 3 times formally at the grander, schemes. Right now, there are 40 recommendations, which are the 40, standards. They deal, when I said earlier, they're very broad and complex and far-reaching. They require elements of doing money laundering, terrorist financing, risk assessment. They are elements of national coordination, domestic coordination. There are issues related to criminal justice, repressive measures. Do you criminalize money laundering properly? Do you criminalize terrorist financing properly? There are a suite of very comprehensive preventive measures that financial institutions, banks, and all those other financial institutions, currency exchange, money services business, but also what we call designated non-financial and business professionals, casinos, real estate, lawyers, and as gatekeepers. There's issues related to transparency, the beneficial owners of corporations and our trust. That's what it means. There are all sorts of standards and recommendations that deal also with whether countries have the appropriate institutional framework and do they have the right tools to do international cooperation, which is very important because the whole issue here is to recognize the crimes are international and we need to work together. Those recommendations are being assessed through a technical compliance assessment. It's really looking at whether the countries have the laws on their books, the appropriate regulations, do they have the right institutions, and do they have the right process? Do you have a financial intelligence unit? Do you have law enforcement agencies that have the right powers to do wiretapping and all those issues? Do you have supervisors that can go on site and visit institutions and have free access to all their books and their process, and can they issue fines and all that? Since 2012, the FATF has decided to start pushing its emphasis still on technical compliance, but really drill down on effectiveness. So this is a new approach. There's very few, if any, international organizations that do that kind of scrutiny on a country's laws and really look at, okay, once you have implemented all these beautiful laws and institutions and processes, are you really producing results concretely? And this assessment is based on 11 immediate outcomes, and I'll go over them very quickly, shortly on the next couple of slides. There's also an emphasis on the risk-based approach because it's recognized that countries should put efforts where the biggest risks are, and we cannot, nobody will ever be able to prevent and disrupt all crimes. And so through this assessment process, countries, as I said, are getting those mutual evaluation reports. So we get a report card and with ratings. And some ratings, the parents are happy, on your report cards, and some ratings, the parents are not very happy. So what you see on the slides there is the ratings when mom and dad are not happy and you're not getting that little, amount of money for a good report card. So in short, and it's a little bit more than that, but for the purpose of the discussion today, is that if you get more than 8 of the 40 recommendations that are PC on NC, which means partially compliant or non-compliant, you're not seen as having a satisfactory level of compliance with the standards. Or on effectiveness, if you have 7 of your 11, which is not that many, it's less than half actually. It's more than half that you can have bad ratings. But if you have 7 of those immediate outcomes that have been assessed as being low or moderate, mom and dad are really not happy. In the FATF assessment process, you're guilty until proven innocent, okay? So you have to demonstrate to those assessors that you do have the laws, you do have results. So you're starting with nothing, and the burden of proof is on the country to demonstrate that it's doing okay. And what I'd like to point out too, it's an art, okay? It's not a science. It's based on judgment, and you can put different people in the same room, and they would have different, probably judgment on a country's level of effectiveness. But it still gives a good ballpark of where countries are situated. So in this new world of the 2012, sorry, Norway is really not showing, but his husband told me, who cares about Norway? No, we do care about Norway for other important things, but maybe not as much in the context of fighting financial crimes. This is the report card we have so far for countries that have been assessed at the FATF. 11 countries have been done. Sweden is the next one coming. It was just assessed at its plenary, at the FATF plenary in February, and so the report should be out in a month or so. Unfortunately, as compared to what we heard this morning from other panelists, it was from the Coast Guard. They were saying the level of compliance was very high with the boats. Well, here the level of compliance is not very good, and I'll walk you through a little bit. The system, the effectiveness of the global system will be as good as the weakest link. Okay, so the minute you have a country that doesn't have very strong rules to prevent or repress financial crimes, this is where the money can enter, and all of us will be, contaminated in a way by this approach. So those are the results on an aggregate basis. The FATF Global Network has done over about 30 reports so far, and they are also found on the FATF website, so you can see other countries like Costa Rica, even Cuba, and a few others. So what we found so far, if you remember the results, 7 and over, not that great. That's why you see it in red. And effectiveness, and in terms of technical compliance, 8+. And over out of 40 is not that great. You can see that only Spain and Italy has had a good report cards where the parents were happy. So that's only 2 in the whole FATF, family. And this is where you have all the developed countries. We have been dealing with those issues for 20-some years plus. We're still failing on laws and regulations, especially, okay? Many of us are still failing. You can see the U.S., on effectiveness, it is done pretty good, but on technical compliance, there's still 10 of the 40 recommendations where the U.S. has been assessed as not having a satisfactory level of compliance. And 2 lines down, you see Canada. The effectiveness, it was, just at the edge of the non-passing marks, but on technical compliance as well, we have several recommendations that we're not dealing with at a satisfactory level. And then you see Australia, Malaysia, Singapore, Belgium, Australia, Norway. It keeps getting worse and worse and worse. The good news is the FATF is not giving up. Okay, every time there's a report and the results are not what they're supposed to be, there is a follow-up process. So this is why you see on this slide, regular follow-up. This is Italy and Spain. All the other countries are expected to go back to the FATF on a more, almost every year and more frequently if we're not making progress, and show that we are addressing those issues through laws, regulations, institutions, processes, or even real results. So that's the beauty of the thing, and I think that's where there is some strength in what the FATF is doing, is we all agree to those international standards globally. It's a bottom-up approach. We agree to those standards, and then the FATF, but it's us still, the countries, is turning around and assessing those countries and say, you have to live up to your commitment, and we have teeth. unless maybe the UN process sometimes that, with UN conventions, and it's been harder to get some countries to move. Here, there are challenges in getting countries to change their laws and a way of doing work, but it is ongoing. Lastly, on this slide, I'm just giving you a bit of an overview of the effectiveness compliance results for both Canada and the United States. So for each of the immediate outcome, and you can see here, they deal with risk policy and coordination, international cooperation, supervision, the preventive measures, the transparency issues, the use of financial intelligence, how we're doing with respect to money laundering investigation and prosecutions, the whole issue of confiscation, terrorist financing investigation and prosecutions, some of the more preventive administrative measures with respect to TF, but also lastly, there's one outcome that deals specifically with proliferation financing, financial sanctions. So you can see that Canada and the U.S. has some strong shared areas of effectiveness, how we assess risk and deal with policy and national coordination, also how we are dealing with international cooperation is quite good, how we're dealing with terrorist financing investigation and prosecution, and also with terrorist financing preventive measures and the financial sanctions. Again, both countries got overall good ratings. Canada has been stronger on the preventive side, how our supervisors, especially in the banking and other financial areas, have been dealing with those issues. And U.S. has been significantly, stronger on repression, but I think we're not surprised by some of those results. This is where you see from IO 6 to 10, the substantial ratings and the high ratings. So at least that gives you a little bit of a Canada-US comparison within the broader scope. So lastly, and I'd like, if we can, keep maybe that slide there for as the panel continue. I'm going to come back to this slide, but I just want to point out that, throughout the day we highlighted the importance of this Canada-US relationship, and it's also very important from a money point of view. There's a massive amount of money flowing very freely between our two countries. We both have no capital controls. We talked about $2 billion in trades in goods and services daily between our two countries. This is just trade in goods and services. Imagine if you add, bank accounts of our joint citizen in the other country, buying of shares, buying of foreign debts and all that. So the money is huge. So those are huge opportunities, but they're also opening opportunities for the criminals to move, money between the two countries. Some of the shared challenges that I wanted to point out between the two countries was the lack of transparency in our two countries with respect to ownership of corporations and trust. Also, the implementation by our respective financial institutions, mostly non-banks, and the DNFBPs are also quite weak. And we also, both countries, do not cover lawyers as gatekeepers. And this is expected by the FATF standards because the risks have been identified there as being higher, and those should be covered area. So I'll come back to some of those issues, but I want to stop there and give the floor to my colleagues. Thank you.
Okay, that's an interesting assessment. I've been a business writer and a business person actually for quite a few years. I don't want to say exactly how many, but it's a woman's prerogative. But for a long time. And one of the things that I have thematically zeroed in on quite a bit as a business journalist is, and also as an investor, is white-collar crime. I've written 10 books about business politics, 3 of which were about white-collar crime. I've done documentaries on white-collar crime. I've done thousands of articles, and I like to say I've put a few people in jail and helped to close some of the worst stock exchanges in the world, which happen to be in Canada. I want to go to 32,000 feet now for the view. I think what they're doing is a great start, and it's not just about countries wanting to make sure everybody plays by the same rules. I want to give you the actual geopolitical risk that everybody in the world faces because this hasn't been properly addressed yet at all. It's been noted by this organization, but not addressed. What we're talking about is massive, and I'll give you the facts, massive flows of illicit capital. We're talking about the routine and constant looting of the developing nations and the distortion of this laundered money and tax evasion money and proceeds of crime funds into the rich countries, with the result of distortion of our real estate markets. We see this in Vancouver and Toronto. It's a theme I've been writing about, talking about, and doing documentaries about for 5 years. And in other cities like New York and London and Hong Kong, wherever, or in Sydney, where this money flows very quickly into real estate, has created real estate bubbles, has created risks to the banking system in terms of mortgaging, has created and is starting to create social issues in terms of affordability of housing and other concerns. That's really what we're talking about. And the numbers are enormous. And the kleptocracies, the people that live in the kleptocracies where this is permitted, are not the only victims. I'll give you an example. The largest country, the largest amount of foreign direct investment that flows for the last few years into the United States is not from Canada, it's from BVI, the British Virgin Islands, with 5,000 people. Billions of dollars a year are flowing in FDI into the United States to buy factories and plants and real estate and politicians and mind share into the United States from goodness knows where through a secrecy haven like BVI, and it's one of dozens of secrecy havens. There is a secrecy, dirty money, tax evasion, proceeds of crime industry that's one of the biggest in the world. And the lawyers are linchpins, and the banks are as well. And many government officials are, and this is what's going on. Here's a figure. The Global Financial Integrity Organization is something that I think everybody should look at their website. They do great work. They're economists, and they have been able to quantify the extent of the illicit capital flows worldwide. Their figure is that more illicit capital through various techniques, and which I'll kind of touch on briefly, leaves the developing economies facilitated by the secrecy industry globally, that these countries get in total in foreign direct investment or foreign aid combined. Africa, biggest victim of all, more looting out of Africa illegally through capital flows such as this. The looting of Africa is greater than in absolute dollars, the GDP growth of all the countries in Africa. It is getting absolutely stripped and looted. So is China. The figures for China, just up to 2013 in 10 years, is $1 trillion. Illegally looted out of that country by officials, by people that run corporations, by individuals through casinos in Macau, through secrecy industries that are in Hong Kong and in Canada and the rest of the world, and in Britain. Russia, which is a kleptocracy and run by kleptocrats, nonetheless has been looted to the extent of almost $1 trillion in the same 10-year period. As I say, the victims are also in the rich countries. We are all paying higher taxes because there are many among us who are cheating, thanks to a secrecy industry that also works in the United States, Canada, and the rich countries, allowing domestic money laundering, proceeds of crime, and capital outflows. Very often the capital outflows go out and they come back again under another beneficial ownership or a secrecy shelter that tax lawyers and other accountants have devised that are very clever but are creating a huge problem. The social costs of high housing, the social costs of the inflation as a result of this coming into certain areas and regions in particular, also victimizes people in those countries that are the recipients of the illicit proceeds of crime and tax evasion and money laundering. The study by the GFI was that since 1980, the developing nations of the world have lost $16 trillion out of their economies. This is, as I say, this is done through skullduggery, through all kinds of things, cash transferred, wire transfers, done through the secrecy industry, as well as misinvoicing. Misinvoicing is a huge problem, and another speaker earlier this morning talked about the GAO's concern that customs duties are not applying properly, and that the valuation of goods coming and going into the countries, all countries, are a real source of leakage and problem. For instance, anecdotally, the customs officials, the interdiction people, discovered that Mexican cartel drug lords were receiving cattle and horse livestock worth billions of dollars every year and paying pennies for it. It was being exported from the U.S. as payment for the proceeds of crime, and they were actually on record charged pennies per head for this livestock. So what they do is they sign away commodity sales from poor countries to rich accomplices for vastly less than the goods or the commodity is worth. That's another form of looting, which is very difficult. The OECD has actually led this, and they are doing a very good job on this. So is this new G20 creation. Transparency International ranks countries overall. And in Canada and the United States, particularly in Canada, we have cracked down on the banks in terms of, and the United States, know your client rules. But obviously a great deal more needs to be done, and it exists everywhere. I think that the legal profession has a lot to answer for in this whole secrecy industry, as does accounting. And I think that it's very important that the same know your client requirements that banks face should be imposed on the legal profession and on the other professions, and enforced, and hasn't been and should be. There is no justification for the privilege that the legal community is given to provide immunity and cover for whoever walks in the door to pay them a fee. It is immoral and it should be illegal. Also, the issue of transparency and beneficial ownership. I could show you 100 buildings, zombie buildings in Vancouver and Toronto, where the ownership changes constantly, where apartments are flipped. Nobody knows anybody who owns anything, and they're essentially, the nickname for them is conceal estate instead of real estate. And this is going on in New York, and it's going on in London, it's going on all over the world. And basically these are safety deposit boxes in the sky that hide sometimes criminal proceeds, and certainly are there by kleptocrats and other folks. So pretty hard hitting is something I'm very passionate about, and I've been writing about it forever. Money laundering is a scourge, and it's a threat to civilization and capitalism. None less than that, nothing less than that. So I applaud what the G20 is doing, and I would applaud anybody in the legal profession who wants to raise this issue, because I think it is the biggest single issue that the world faces now. Countries that are looted become destabilized, become failed, and become terrorist nations. It's all linked. So on that kind of preachy note, I'll turn it over to my friend here.
I have to start out by sticking up a little bit for the British Virgin Islands because I led the anti-money laundering assessment there, and they were no longer, they haven't been a secrecy jurisdiction for ages. And we concluded that they had a far better AML system, particularly with respect to preventive measures, than did the US or Canada. So let's hear it for the British Virgin. They also have great diving, I just want to point out. But I think there is it's an issue that particularly, I will bring the legal perspective to this for a second. A little bit of confusion as to what it means when money flows from country A to the British Virgin Islands or some other offshore center to the United States. Money doesn't flow anymore. It's not like there are, I don't know, culverts or something where they dump the cash and it flows. What it really means is that another jurisdiction's law is applied to the transfer of ownership rights to bank accounts. So money doesn't actually flow into the BVI or anyplace else. And one of the reasons that there's a gazillion dollars that, at least temporarily, is under the jurisdiction of the British Virgin Islands is that English law applies, and you can trust the judges there. You can trust the laws and the judges there. So I've described the BVI and the offshore, the Isle of Man, Jersey and Guernsey, for example, as exporting the rule of law to parts of the world that don't have it. So while it is certainly true that looted money might be looted and sent through offshore jurisdictions, meaning offshore with respect to, say, I don't know, just to pick one country, Nigeria, that's had a lot of trouble with looting. Both the criminal element and the honest element are afraid to have their financial resources, meaning their claims against banks, which is, when you have a bank account, all you are is an unsecured creditor of the bank, right? Everybody knows that. So they would rather have that creditor claim not be enforced by Nigerian courts, but rather be enforced by Hong Kong courts or BVI courts. And I think in the fight against money laundering, that's something that's essential to understand, that really the jurisdictions that are the places where the money is flowing through, they're the ones who are enforcing the rules, such as, and to go back here, and also the previous slide, to preventive measures. So I always thought it was interesting that in the new methodology for assessing outcomes of effectiveness, 2 out of the 11 apply. It's really only 1. Preventive measures is just 1. I think isn't it 4? Implementation of preventive measures. And number 3, I think, is supervision. So, and I think those are extraordinarily important because the anti-money laundering framework was brought into being and has been improved through the so-called preventive measures system. Now, the preventive measures system, they said, okay, a lot of money is flowing through banks, illegal criminal proceeds, profits. So what we're going to do is we're going to turn banks into snitches. We're going to turn them into unpaid law enforcement agents, in effect. We're going to require them to identify their customers and monitor those transactions to see if they suggest that they might involve criminal proceeds, that might involve money laundering. And it's an expensive thing for banks to do. They have to identify their customer, build a profile, have some sort of system for monitoring that profile, monitoring transactions to see if it fits with a profile. If it doesn't, then it goes to the financial intelligence unit within the bank. There are investigators there. They decide whether they should be a snitch. It used to be drop a dime. I don't know what it is in Canada. Can you imagine? There used to be payphones. But essentially send a little note to law enforcement and say, we think our client here might be involved in something bad. And then that goes to law enforcement. And that was really the basis of probably all of the anti-money laundering, all of the measures, but principally these are called the preventive measures. Now, the other reason we had banks do that, and not everybody, not, say, lawyers, which are now required to do this, designated non-financial businesses and persons, real estate agents, et cetera, was not just that money illegal proceeds tended to flow eventually into banks, because if you want to be part of the formal payment system, in other words, not pay with things with cash or diamonds or something, you've got to have a bank account. And so banks should be involved. It's to start hauling big satchels of money around, somebody might notice, and then they would report you, or they might notice and steal it from you. So it's much better to have a bank account. But also because banks are subject to supervision, annual supervision, where people actually show up in your bank, and if it's a big enough bank, they're there 365 days a year, and I mean Saturdays and Sundays as well, but they actually show up and they do a detailed examination. Originally it was just for prudential purposes, and then eventually anti-money laundering was tacked on, so they had to do an anti-money laundering examination. So they're actually physically there. And also for banks, a typical bank, there are 4 really big ones in Canada and 400 in the United States, has more customers than just bad guys. They take money from both criminal elements and from the honest elements, and so they didn't want to get in trouble for bringing in criminals, because the supervisors, the folks who were doing the examinations, could then penalize them for that, and that would affect their legal business. So it's a very good way of ensuring that financial institutions, and principally banks, actually comply with these preventive measures, which then allows them to be snitches on their customers. And their customers, at least some of them, are likely to be money launderers, because money launderers, or criminals in general, want to get their money into the formal financial system. So that's kind of the way it's set up. So I think Canada does a much better job of this than showed up in the evaluation. There is a good reason. Among the good reasons for that is, I'm half Canadian, but that's not why, is that supervision in Canada, in general, prudential supervision, is much more effective. It's much better than it is in the U.S. Now, it could be because it's just the federal government that does it in Canada, and in the U.S., oh my Lord, just one agency, the number of federal agencies, 1, 2, 3, 4, 5, and then we have 50 states that also get involved. So there's a great diversity in the supervisory community. It's also, we just have many more banks here in the U.S. than in Canada. Canada is not as large a country. I think it's also attitude. And if you look what happened in 2008, Canada avoided the financial crisis. And I think clearly, it's not just me, I think there's a general consensus that part of the reason for that was much more effective prudential supervision. If you add anti-money laundering supervision to that, it's just a natural, although it's not the same people who do it, but it is within the same system. So you have expert examiners who look for, to assess the quality of preventive measures in Canada, which you don't have in the US. But you just have a more effective system of bank examinations in general. Now, let's turn to lawyers, designated financial businesses, and persons. How many lawyers are there in the US and Canada? The technical term, I think, is a gazillion, yeah. So how many, how many jewelry dealers are there? How many real estate agents are there in these places? How many money services businesses, check cashing? You add those all together, you get a lot. So when you turn and say, well, essential to our immediate outcomes here, looking at the effectiveness of implementation, if we extend preventive measures to all the lawyers and all the jewelers and all the real estate agents, do you think that there are going to be folks out there who are going to be able to supervise the implementation, just like you do for banks in money services business? In the US, the money service business is supervised and compliance is assessed by the Internal Revenue Service. Guess how many agents they have assigned to that? I won't even tell you. Tiny. There's no conceivable way they can do that. If you were adding lawyers into the mix, how would you, do you think, I don't want to say anything that might sound, what's the word? I don't want, no, I'm a lawyer, I can do that. I'm just thinking of ethnicities, but there's a traditional consigliere in Italian, right? The person who is the lawyer who works for, yeah. So I'm guessing there are actually lawyers out there that will agree to work for criminals. I mean, wouldn't that shock you? And can you imagine if the government says, gosh, gee whiz, you are supposed to be knowing your client and sending in suspicious activity reports to the police if you think your client is a criminal. Do you think they might be able to find somebody who won't do that? Yeah, for everybody else as well. So to me, it's become such a red herring, and it's actually negative, because while we should be focusing on banks that are supervised, right? The quality of the supervision, particularly with respect to anti-money laundering bank examinations, focusing on that. Instead, we're getting distracted into something that is never going to find a bad guy anyway, because they're going to get a criminal to do it, a criminal lawyer, a criminal, somebody else. I have the focus also on transparency. I think it's always good that financial institutions should be required to ask who actually owns a company or who actually is the beneficiary of your trust. It's a good thing, put it on record. And part of the bank's duty with respect to its due diligence, monitoring transactions, sending in that, becoming a snitch and sending that note to the police saying my client might be a bad guy, would be to look at the identified beneficial owner, and if it's Mickey Mouse, or if it is Richard Gordon and $10 billion is going through it, they can say, that doesn't make sense. Why would Mickey Mouse, who doesn't exist, be listed as the owner of the beneficial owner and controller? Or Richard Gordon, we do a little looking and we say he is not a lawyer to folks out in Silicon Valley where he can make $1 billion. No, he just teaches a case where they pay us $5 an hour. So that is part of the due diligence. That would make sense. But that's not what this is about. It is, we are going to assume that we've been told the truth. Can you imagine a criminal setting up a company somewhere and lying about who the real owner is? I would be shocked. I would just assume everybody tells the truth. I think more likely all the bad guys will lie and all the honest people will tell the truth. That's just a guess. We'll find them if they don't tell. Hi, I'm an international drug trader who kills 10 people a day for the fun of it. You should see how many people I kill for business purposes. But I will be so scared by the $5 fine if I lie. I don't think so. So it's a good idea that has taken off. So we're concentrating on things that are not going to stop money laundering. More resources, because of, I think, the misallocation here of interest, more resources are going down dead ends and not going to the very important, very basic side of anti-money laundering preventive measures, which is the banks that are subject to actual ongoing supervision by experts to see if they're implementing their anti-money laundering requirements. I think Canada does a better job of that than the US, and I think the US and Canada do a better job of that than lots of other jurisdictions who will be, based on this system, perhaps focusing on the wrong thing. But that's just my personal view. I'm not speaking for Case Western Reserve Law School.
I agree with you, Canada does a better job of supervising, and that's why they took the case about bringing the lawyers into the loop to the Supreme Court of Canada. So the government of Canada saw this as a real gaping problem, the legal issue. So you want to tell them about that, because I found that very interesting. They didn't win the case. The Supreme Court is, of course, lawyers, but...
That's the problem. The world is run by lawyers.
Because it's the right thing to do.
Well, I appreciate the perspective that Richard is bringing to the debate on how far those AML rules and international standards have been pushed, and sometimes are they really having an impact. But I think we'll come back to that a little bit. But on the issue of just lawyers and lack of coverage as gatekeepers, let's assume it's the right thing to do for now. That's what the international standards that all the countries around the world have agreed and signed on to. So, but we can debate that. I think that's very healthy. But let's just assume that for now. The FATF pushed for lawyers to be added to the list of, gatekeepers in the mid 2000. I forget, it was 2003 or 4. I forget, it was in the last revision of the previous revision of the standards. Canada had identified, when we did a major revamp of our AML laws in Canada under the Proceeds of Crime, Money Laundering, Trust Financing Act and the regulations, and we created one supervisor for AML, which is FINTRAC, which is the equivalent of FinCEN in the US, but it's the only AML supervisor in Canada. OSFI, which is the Office of Superintendent of Financial Institution, which is the Prudential Supervisor of banks and other federally regulated financial institutions in Canada, is supporting FINTRAC on its AML supervision. So they're doing it together now in Canada. So with banks, they deal with 2. In the U.S., there's like 15. Anyway, so that's a major difference. But when Canada revamped its system in 1999, 2000, and then 2001, in light of 9/11, they included lawyers as gatekeepers, and immediately the lawyers challenged the federal government. And due to that challenge, the federal government said, wait a minute, we're going to not implement this. We're going to try to negotiate something. And it was tried and failed, those negotiations. The rules were changed a little bit. Lawyers were no longer required under the revised rules to report suspicious transactions to FINTRAC, but just to keep a record and do it through the law societies at the provincial levels. Despite that, the Law Society of British Columbia took the federal government to court, and they won in the BC court. There was a British Columbia. The federal government then won, challenged that, won in the Superior Court, and then it went to the Supreme Court. So the Supreme Court decision was rendered in 2015, I think July. And the decision was that all the rules with respect to lawyers are now inoperative in Canada because they are unconstitutional. The rationale was just the search provisions, of FINTRAC as a supervisor. The access to the records and the search provisions were seen as infringing, some sections of the Canadian Charters of Rights, and it was in relation to the solicitor-client privilege in that area. So the Supreme Court did not say, no, federal government, you can never apply such rules to lawyers. They just said you can, but you have to redesign them and make them constitutionally compliant. So the federal government, since this decision is, and they said that they will be working on new provisions for legal professions that will be constitutionally compliant, and nothing has been announced so far. I know from the Department of
José,
Finance.
what do other countries do that have
It's all
reined it
over,
in? It's all over the map?
It's all over the map. The U.S., they didn't even try, and I don't think they will. In Japan, they never tried. In the UK, it's operational. It is working, and it's a common law country, so that's interesting. In Australia, it's operative. And I forget, it's all over, it's really all over the place. So that's the reality, the reality at the FATF, and I think it goes back to the heart of what Richard was getting at. You have, don't quote me on that, but you have a couple of people at the table at the FATF that are all about rules and making better rules, and it sounds better, and too often the reality, it's continental European countries that have a very important voice, and it's all about making more rules, and us more pragmatic common law, those are mostly civil law countries. I love them, you know.
And you're from a civil law jurisdiction.
Well, it's still within a common law, you know, country, but yes, I come from the
You're
province of
saying
Quebec.
you're not prejudiced. that's
Yeah,
all.
no. And again, half of my history comes from France, but the other half come from the UK. And so that's the reality, and I call them Planet Europe sometimes. It's all about making more rules. They're rules-based countries. So more rules is better, which we finally won, I think, at the FATF table through the last round of negotiation in 2012, was to limit the number of new rules, and can we make sure the rules are implemented? And this is the focus of effectiveness. So gaining support from all the FATF members on focusing on effectiveness was a huge, huge victory for common law countries. And we are a minority in the world, common law countries, and we are a minority at the FATF table as well. So anyway, I think that's, I'm with you in a way, but I still think making more rules sometimes makes sense and is needed. It won't be as effectively monitored in terms of supervision, of course. You know, in Canada, we have to supervise, I don't know how many hundreds of thousands of real estate agents, and we're doing it through FinTrack. It's more a risk-based approach. It's, you know, there's ways you can still do it, but it won't never be as supervised as, you know, prudential institutions. It still makes life harder for criminals, and I think that's the idea.
Yeah, and teachers and doctors have to report abuse.
Yeah.
Some things are in the public interest.
Yeah. Sorry, there was maybe we can open,
Yep.
I don't know if you guys want to say more at this point, or,
Thank you. I listened to this with a great deal of interest because I was the minister who had the great pleasure of bringing this legislation into being back in 1992. And the biggest issue we faced was whether lawyers should be involved and included, and we were fighting like hell to get them in there, and they were fighting like hell to stay out, and I thought they were going to revoke my license to practice law in Ontario, and they were screaming louder at me than they were at the Premier of Ontario when he took away all of their Queen's Counsel designations. So it's, I'm glad I'm not the only politician who was...
but the fight is not over. Yeah, but the fight
Congratulations.
is not over, you know?
I was just,
Yeah, I think, sorry, maybe I missed you, or we'll come back to you right after.
Just a small comment, Richard. I think you were too generous to Canada. In fact, we are abysmal in terms of disclosure, publicly or privately, of who owns corporations. That's at the federal level and every province. It's the Brits who are way ahead of us, who've gone and changed the law. I think it's, my understanding, very limited, is that you have two particular states that are very popular for these secret companies, Nevada and Delaware. But there may be more, but we're just universal. You can hide your ownership, trusteeship, whatever, in any federal or provincial jurisdiction in
I
Canada.
have a two-hander
And,
here. Based on facts, though, it's true as well in the U.S. It's as bad in Canada and the U.S. Where Canada is a little bit better is banks are required right now in Canada to ask who is the beneficial owner. In the U.S., they're not required legally yet. They will be with the new rules in 2019.
Yes.
And it's not covering all the financial institutions. So in a way, the U.S. is even worse than Canada because the legal owners are known. We're talking about the real natural person behind, you know, and who controls the company. And the U.S. are actually is worse. It's not just Nevada and Delaware. It's all the states Like it's all the provinces in Canada.
And-
We're very bad in Canada, but the US are quite worse in a way because the system through banks and financial institutions is through preventive measures and know your customer and do customer due diligence is not even there in the US. So that's the difference.
And it's true the UK even now has a shareholder public register, and who identifies that someone is the beneficial owner and controller? The person. In other words, you can lie, and I'm pretty sure that criminals do lie. So I don't see. I know. So, but I would actually disagree with the idea that, well, it's okay to have that because even if it doesn't work, so what? I think it's bad because if you start directing resources, and of course this is the whole issue with doing an assessment, before doing an FATF assessment, countries are required to do a risk assessment first. And you identify the risks and then you deploy resources to those areas with risk so that you can mitigate them. If you have rules that basically are just fool's errands, I mean, what I suggested I won't say where he was from, Norway, about having requiring that have a public register with self-identified beneficial owner and controllers. I said, why do you stop there? Require every person in your country to identify if they are a criminal, and put that into a public registry. And if they don't identify themselves as a criminal, then they have to pay a $5 fine. I mean, and
There was, I think there was
and
a
I
question.
okay.
Oh, that's good.
Thank you. In fact, Jose, I wanted to ask more about the Financial Alaskan Task Force, and that is, you talked about, for example, countries whose scores are not good enough. You sort of alluded to the parents' disapproval. But what are the practical consequences of not having a good score, either from other governments or markets or anything else?
Okay, well, the first practical consequences are from the FATF as an organization. And again, the FATF is a task force and it's consensus driven and it's the members. So me, when I was head of Dell until last December, it's all of us, the bureaucrats, under ministerial guidance or mandate that make those decisions. So the first level, as I said, is this more regular reporting. So as a country, you get the bad report card. You're not off, like the FATF is not off your case for 2 years or longer. You have to report a year later. And an FATF report on the 40 recommendations and 11 outcomes, I spent 3 years of my life being under the FATF review for the last report of Canada. It's huge. It's touching on everything. So just that is a burden that you have to prepare the report, get it approved, send it. So that's the first level. If you're a good citizen and you report and you show that your laws are being improved or your results are better, then, it's not that bad. The second layer is that if you're not making progress, and a few countries were under that process, not that in the previous round, you get a high-level visit from an FATF delegation from different countries, from other countries. So then you meet ministers and parliamentarians and you make, pressure on them to show, well, listen, you're dragging your feet. We've done that to Japan. We've done that to Brazil, and there's a few Turkey was under that so then you have to brief your ministers. You have to, there's nothing public really at that point. At a certain point, if a country is still dragging its feet, it goes to a public listing. So the FATF does a listing of non-compliant countries. So you do get mentioned publicly. So this is when it starts to maybe have a little bit of an effect on your reputation. Some investment, could have some negative impact on your investment. The next
Get a lot more money laundering business.
Yes, maybe. It's a good publicity for that kind of business. The next level is you can be suspended by the FATF or then you can be expelled by the FATF. And again, not good for any country to be in that situation. That's for the FATF members. The FATF also does a review of all the all the countries around the world, not just of its own membership, and it does this high risk, assessment of countries that are not compliant. When I was the head of Dell, we were doing a review of Trinidad and Tobago, and we found them non-compliant. They were put on that list. I was chairing a regional committee that was doing this assessment. I got a call from the Minister of Finance from Trinidad and say, okay, like you explained to me the process. We are seeing an impact on investment, and we're going to, get our laws in order, and we don't want to, be going to the next steps and all that. So it has quite real teeth.
Yeah, shaming does
and
work,
shaming,
and it leads to interdictions and sanctions very often, and real problems. If you look at the trajectory of the fact that Canada has started to rein in its banks, they were notorious in the Caribbean, and that's where the dirty money was all going. Until there were some high-profile insider trading cases. Dennis Levine in the 80s, and the Bank of Nova Scotia. There was a general who had hidden away a lot of money with the Bahamas. So Canada was really, its feet were held to the fire, and our banks were, by the American governments and other governments over this, who were doing the investigations. The British were doing some. And look at all of the scandals that involve Switzerland. So it eventually forces better behavior, and it does, not always. So Switzerland is no longer the capital for dirty money. It's Singapore. It's switched to Singapore, but anyway, they'll get pressure as well. But to the extent that they get pressure, so the shaming does very often lead to improvement.
And there's something even prior to shaming, which is that pretty much every jurisdiction in the world requires its financial institutions to engage in a due diligence process, quote unquote, when they engage in relations with another financial institution from another jurisdiction. And if you're the U.S. in particular, and the dollar is king still in international trade, if you want to have a dollar-based account, you have to have a U.S. correspondent bank. So if you're the respondent bank in country X, pretty much, if you're big enough and you're involved in international commerce, you have to have a corresponding bank relationship with the U.S. bank. So under U.S. law, then you have to engage in a heightened level of due diligence. Due diligence? I don't know. If the bank, the respondent bank, is in a jurisdiction that does not comply with the FATF recommendations. So, and that is taken seriously. And it doesn't mean that the jurisdiction has done really poorly or has been sanctioned by the FATF. It's just even slightly worse. They have to increase their level of due diligence, which usually means I have to send a couple of officers from my compliance department over to country ding dong and see what's going on and see if that bank is implementing anti-money laundering policies, even though the country itself is not doing so, say, through banking supervision. That's expensive. And there is an entire, God, I'm on one committee, I think you're on one too, concern over so-called de-risking, which is particularly with Caribbean banks and some other banks, which is that they're honest banks, right?
Some African countries.
And some and certainly the Middle East and South Asia, and where the amount of money that is being corresponded with is not very big. So if I'm a U.S. bank, and it turns out it's a small Caribbean bank that cannot operate, because you have to import everything in the Caribbean pretty much, it cannot operate without a dollar, without access to the U.S. dollar. It can't get a corresponding bank relationship because it would be too expensive for, I don't know, let's just KeyBank, too expensive for KeyBank to do the necessary due diligence required, because the FATF has said, Trinidad isn't doing particularly well. I did an assessment of Niger, and I was surprised at the amount of resources that was going into implementing the preventive measures provisions for banks in Niger. Niger is a very poor country. There's a revolution going on in the north, had terrible trouble with malaria. In fact, it's a desert country. It has malaria. I remember going out of the airport and asking my cab driver, Everything has, centre contre something else, the center against. And I got everything and I said, centre contre la paludisme. And I said, what the hell is that? And he said, malaria. I said, you have malaria here? He said, starting tomorrow when the rainy season hits. You'd think more resources would be going into preventing malaria, dealing with the Tuareg rebellion in the north, later ISIS. And I said, why so many resources? He said, if we do not effectively implement our anti-money laundering, particularly at the preventive measures side, which is expensive, we will get a bad rank from Java. What's the Niger is in Java? It's a FATF-style regional body. And if that happens, we're going to lose our franc accounts because banks in France are not going to agree to have a corresponding relationship with us. And it shuts us down. So it's that powerful.
Yes, maybe one or two more questions. We're going to have a whole day on this.
Practically speaking, how far down does a bank have to dig in due diligence in order to find a beneficial owner? Because, there can be so many shells. If you have an LLC and the members are all limited partnerships and the limited partners are all LLCs and on and on and on, you can go down any number of levels before you ever find a live person. So
the standards are quite specific that you have to find the natural person that controls directly or indirectly. But there is a carve-out that kind of says if that cannot be found, then you treat that company as a higher risk, and then you apply enhanced due diligence, and you find another warm body within the organization that you can make, like the senior person or whatever. That's how we have implemented more or less the rules in Canada, but again, it can be implemented many different ways. We have also put a threshold, like ownership of 25% or more, directly or indirectly, so you can drill down. But some countries don't have thresholds of share ownerships and all that, so it's a bit all over the place. A public registry, just quickly on that, is it could not really be done in Canada because of privacy issues. Financial information is private, so with the Constitution, I think we could implement that. But personally, I think garbage in, garbage out. It's people do lie. It's a bit harder to lie to your bank because banks are supposed to check the owner of the account, the owner of the corporation, know the purpose of the account, the business purpose of opening that account for the customer, and do ongoing due diligence, like monitor transactions. So based on those things, they are much better placed to find out whether the money flows is consistent with, Jose now is a consultant, I'm not getting my paycheck every 2 weeks, I'm getting those amounts of money. Is that like what has been happening to our account? No drug money, don't worry, it's all legitimate. But that, so banks are better placed to monitor that than any public, officials maintaining a public account of ownership of corporations. So in Canada, what was announced, though, and this is an area of cooperation I think would be great, is that the minister in his budget last week, the Minister of Finance, announced that he's going to be working with the provinces to develop a national strategy to deal with beneficial ownership issues, including in the context of tax. Because it's also a big issue in the context of tax. So they're going to be working on that. But what will the Trump, administration decide to do? Will they ever want to push forward that issue at the registry level? I don't know. We have no signal so far. So
recent example of the Canadian situation vis-a-vis the U.S. situation too is that the Clinton Foundation took money from very unsavory people. That was not really a good idea. A lot of the money went into a trust in Toronto, a Canadian trust, and the donors will remain secret. So where they could force any foundation in the United States, the Clinton Foundation, to disclose the donors, the actual donors, or lenders, or whatever, they just made one step north, set up a trust in a solicitor's office in Toronto, and off the hook. So we don't know where hundreds of millions of dollars into the Clinton Foundation have come from.
But hopefully they're going to deal with the trust as well.
But, Lisa, in the United States, the rule that's going into effect, as Jose said, by the way, Professor Jose, because she is actually an adjunct professor here, that the rule just requires the bank to ask and then give a form to the person, and they sign and say, if 25% or more of this entity is controlled by a physical person all the way through the chain, as you described, then you voluntarily disclose that and put that person's name down. Now, there had been proposals floating around in Washington that the banks would have to conduct due diligence with respect to whether that was actually the real person. Now, the response of the American Bankers Association, the other ABA, as I'd like to call it, as opposed to American Bar Association, was if we do that, we will have no money to do anything else. Can you imagine? We have tens of thousands of businesses and trusts here. We would hire all the FBI agents in the country and all the RCMP in Canada just to chase down 2 or 3 accounts, and it'll turn out that they're honest. So,
on that cost, like quickly, on the whole, like you all heard about those big fines being issued in the U.S. and the reaction from a lot of the big banks and hiring more and more people in compliance. Again, stepping back, I think we will collectively, the community will have to reflect on what's the best way to tackle this issue, because it is quite costly right now, and that's more and more what we are hearing. But in part, many of the banks, and you saw the results on implementation, and actually no country except one, but that was a mistake by an assessment, no country has scored a decent rating for implementation of the preventive measures. So, our position in Canada, my personal position has been, can we find a good way to implement those rules first before we put new rules? If many of us were doing a much better job in the implementation of the rules, we would be, far better in fighting financial crimes globally. So that's...
Well, maybe hopefully they'll be a bit like, if they do hire all these guys, maybe they'll be a bit like the Mounties in the great musical Rosemary, out on the trail like a pack of hungry wolves on the trail, right? That would be good.
All right, well, let's give our wonderful panel a round of applause. Thank you so much. And now I would invite our Canadian National Director, Kai Carmody.
Oh, thank you. My sister Sorry, we have to run.
Oh, that's okay, that's okay.
we have to.
That's fine.
I've been asked to say a few words of closure and thank you to end this conference. For those of you I haven't met, I'm the Canadian National Director, and I teach at University of Western Ontario Faculty of Law, one of the 2 partner institutions in this institute. I've attended these meetings since 2000, and this conference in particular promised to be one of the potentially more controversial ones. In looking at the conference lineup and hearing from several of the panels today, I'm always impressed at how much we have on one side of the ledger, sort of lots of visions of cooperation, but also looming on the horizon constantly, much potential for conflict, frequently diffused so skillfully and with such great diplomatic aplomb by many of the attendees who are here regularly and irregularly. On the cooperation side, we had a wonderful set of panels with people like Julie Gascon, Betty Sutton, and Julie Ryan, as well as Peter Bates just after lunch. and David Holtz, Chris Ziegler, and Gitan de Silva, who stressed the common cause and gave us some very graphic and I think some hopeful signs, examples of people on both sides of the border who are working together. As Congresswoman Sutton noted, the Great Lakes regional economy is the third largest economic entity in the world. It contains 20% of the world's fresh water. And it shouldn't be called, as she reminded us, the Rust Belt, but the Opportunity Belt. And on a bit of a personal note, I took a little walk yesterday morning in the driving rain along Euclid Avenue here in central Cleveland, and I could see evidence of that opportunity and transformation in all the construction, much of it related to the Cleveland Clinic, throughout the city. The city has changed enormously since I started coming here almost 20 years ago. And it's been dotted since that time with all sorts of snazzy office buildings and eateries, and even a high-tech bowling lane if you just walk up a few streets. So it's really quite impressive. It looks like a lovely place to live and a great place to work. At the same time, I think our conference proceedings today were evidence of the fact that the relations between our two countries are not all sweetness and light, at least not all of the time. Our financial integrity panel just noted that both of our countries have some strong areas of performance, but also some areas of great lag. There's also the perennial conflict side of the relationship. No one, I think, can ignore the words that were spoken by Terrence Stewart this morning when he noted most presciently that there have been 40 years of stagnant incomes here in the United States. Very few people have addressed this. The stagnation has now resulted in the election of a president who routinely derides other countries and has taken a very wary approach and a skeptical approach to internationalism. As he said in his inaugural address, from this day forward, a new vision will govern our land. From this day forward, it's going to be America first. And one of the planks of that America First platform program is going to be to make the trade deficit disappear, something that I think we heard about in some detail this morning. And that is going to involve, first and foremost, the renegotiation of America's preeminent commercial commitment under NAFTA. And that possibility, renegotiating NAFTA, might have seemed laughable at a conference like this just a year ago. But I think it's a testament, perhaps, to perhaps some of our own short-sightedness, and perhaps some of our own complacency, that we're now having to deal with this after the fact rather than before. It's important not to be complacent. And to his credit, Ross Hornby, I think, laid out for us 3 potential negotiating scenarios that now might arise in the renegotiation of NAFTA. Ross pointed out to us that there's a sort of quick and really dirty option that we might face, where the United States basically says, take it or leave it, and threatens to walk away. There's also the possible of a broader revamping of the agreement, something that I think the Canadians would favor, but something that may also be messier and harder to contain given the election timetable and the possibility that long negotiations can get bogged down and drawn out, and somebody with his eye on the election schedule in the United States may not want that to happen. And then also the possibility of a complete breakdown, something that we have to be prepared for. And Ross indicated that despite strong economic behavior over the last few months and a very frothy stock market, for those of you who are invested, the reality is that we are entering a time when investment has essentially come to a halt. And he noted in his comments, which I think were very useful today, we're entering a pretty scary time. We were also reminded by Jim Blanchard this morning that the original NAFTA passed Congress in 1993 by a squeak, and any need to pass similar legislation today probably wouldn't make it. And that's wise to remember, particularly as we look back especially when we eulogize or would attempt to eulogize agreements that have fallen by the wayside, like the Trans-Pacific Partnership. There's no guarantee, he reminded us, and I think he reminded us very wisely, there's no guarantee that something like that would have passed, even if somebody like President Hillary had been in the White House today. Bruce Heyman's observation is very useful. It's one to recall, and he said that it's important to realize that going forward, we may not be dealing with a rational approach to trade negotiations by this administration. It will most likely pursue a kind of asymmetrical strategy, and we have to be prepared for that. NAFTA's renegotiation comes up against the reality, I think pointed out very presciently by Jim Peterson and others, that Canadians need to diversify their foreign trade very quickly. We're trying to do this, and at the same time, I think we were picked on this morning by Alan Wolf, who said that we're being a little promiscuous. But maybe that's because we have to be. Remember America first. And Jim Blanchard also cautioned us to beware of false narratives and the worrying trend in nativism and protectionism, and this idea that international trade is responsible for so much economic carnage seen in the last few decades, when many people, and I think many people in this room would agree with the fact that there are broader forces at work in the economy that are harder to encapsulate in a soundbite or a tweet. As Jim Peterson related this morning, most of the job loss has been caused by changes in the broader economy and in particular in innovation, and his statistic reminded us that Canada steamship lines used to have 23 workers on the typical Laker, whereas today, with all the innovations that have taken place, that crew has now been reduced to 5 people. And this points not necessarily to more protectionism, to the need for more protectionism, but for broader things like job retraining and skills-based enhancement, like measures of income security for those who are job displaced, and for the need for pension reform, so that those who are facing an old age don't have to do so with the prospect of poverty. Alan Wolf has also reminded us in his remarks this morning that there continues to be, and perhaps there will always be, a strong measure of support for Canadian business and for Canada in Congress. And let's hope that that will continue, and let's hope that our relationship will continue to be as strong as it has been in the past. I'd like to thank all of our sponsors, but in particular our platinum sponsor this year, DLA Piper, and our gold sponsor, Dickinson Wright. I'd also like to thank my fellow directors, Steve Petrus of Baker Hostetler, who is with us, and especially to the Institute's indefatigable managing director, Ted Perrin, who is down here at the front. Both Ted and Steve have worked very hard over the last few months to put this conference together, and they continue to do so year after year with very great aplomb. And I can certainly say that I think in Ted's case, he gets most of his energy, or certainly some of his energy, from his lovely Mexican wife, and that's a small little pitch for a trilateral approach to NAFTA. So thank you very much, and we look forward to seeing you again this year. Merci beaucoup à tout le monde. Muchas gracias, and safe home, everybody. Thank you.
Thanks a lot. I'll be very quick. Just wrapping up, Kai, that was a wonderful overview. Thank you very much. I want to reiterate the thanks that you have given to people here. Just let me say this, in a very short time that Michael Scharf has been the dean of this law school, all of us have noticed an incredible change for the better in the law school itself and its rankings nationally, but also in the functioning of Cousely. And it's because of his inspiring leadership, I think, in the law school and with us, that we have seen these changes for the better, and that we do have people like Steve Petrus and Ted Perrin, who are such capable and competent and wonderful people to work with and give it such leadership. So thank you very much to Case Western, its dean, and the people who represented here today. And let me also say thank you very much in conclusion, on behalf of Jim Blanchard and myself, to the wonderful members of the executive committee who have gotten most of the credit for this and don't deserve it, but who have brought to us a great deal of judgment and support. And from the American side who are here today, that's Rick Newcomb and Dick Cunningham and Jim Blanchard, of course. And from our side, Canada, it was, of course, Larry Herman, Ross Hornby, Kai Carmody, and Diane Francis. Would those of you who are still here just please stand up so everybody can see you? And any of the panelists who are here, let me add my thanks. You're an outstanding group today. We were privileged to have you. Thank you so much.
Thank you again. Anybody who is sticking around, I know many people who are staying at the Glidden House will retire there for some more time together, but if you have other things to do, planes to catch, you've been a great audience today, so thank you.